Good morning. Good morning, my friends. And thank you so much for coming to spend part of your Monday, July 15th with me, 2024. It's a hot one out there today in New York. How's the weather by you? Good morning. Yesterday was kind of wild, huh? Looks like we're going to have a nice intimate stream today. It's early. It's 10:30. It's a little bit late because StreamYard is having issues. So, mods, if you notice any issues or glitches with the stream, let me know because StreamYard had an issue just getting on today. As usual, it's always something. It's Monday, and that's what it is. So we did not cover the Alec Baldwin trial together, as you know, but some wild stuff happened on Friday. It was wild. I know a lot of you did. Hit the like button while you're thinking of it. A lot of you did follow the Alec Baldwin trial, and it was shockingly cut short on Friday when the case was dismissed. It was crazy. It was crazy. It was supposed to be something like a 2-week trial. It was wild. So Tuesday I did 2 shows with you. I did a show with Craig Bates, who was the AV squad team member of Team Karen Reed. Remember, he sat at the little tiny desk. If you did not watch that show, it was a lot of fun. And he had some great insight into stuff that went on inside the courtroom. And it was a great conversation. So we did that on Friday. And then I got the Commonwealth's response to the Reed motion regarding the jurors, and we went over that. I did that with Mark Betterow in the afternoon. So it was wild. So I missed all that stuff that happened with Alec Baldwin. And then I spent the weekend just kind of binging it and kind of like going to watch everyone's reactions to it. You know, all the law tubers and other creators that I like that were covering it. And it was crazy. So for those of you who don't know, I wanted to go over that with you. And as I was watching all of that stuff unfold on Baldwin or rewatching it and rewatching it and rewatching it, there were so many similarities to the Karen Reed case that it was just too hard to ignore. And I was thinking to myself, why can't we teleport the judge, Judge Summer from New Mexico, to Dedham? Because the differences in the way that this judge is Mary Marlowe Summer handled the Alec Baldwin case and between that judge and Judge Beverly Cannoni in Dedham, Norfolk County, Massachusetts, is like night and day. It's like night and day. And those of you who followed all of the pretrial stuff about the Karen Reed trial with me know how difficult it was for the defense to get any sort of basic discovery out of the Commonwealth, how they consistently violated discovery orders, how they refused to hand over basic items of discovery, including the clothing, animal control records. I mean, so much stuff was hidden from the defense in the Karen Reed case that when you watch what happened in Alec Baldwin, you're going to go, huh? How did that case get dismissed on day 3 of testimony, by the way? And how did the Karen Reed case even get to a jury at all? Based on everything that we know and we have seen unfold during the course of the Karen Reed debacle, let's just call it. And I know that so many of the people in the Karen Reed case, including Lally and the judge, and even, I think, even Alan Jackson, maybe in his closing, quoted John Adams. And I thought, well, there's got to be a good John Adams quote for what I'm about to talk about today. And sure enough, here it is, my friends. Here it is. Pull it up for you because it deserves it. John Adams said, "It is more important that innocence be protected than it is that guilt be punished. For guilt and crimes are so frequent in this world that they cannot all be punished. But if innocence itself is brought to the bar and condemned, perhaps to die, then the citizen will say, quote, whether I do good or whether I do evil is immaterial, for innocence itself is no protection, end quote. And if such an idea as that were to take hold in the mind of the citizen, that would be the end of security whatsoever. And that is a quote by John Adams that I find to be appropriate for today. So it was wild. How many of you covered the Alec Baldwin or watched the Alec Baldwin trial, and how many of you did not? If you did watch it and you know what happened, put a 1 in the chat. If you have no idea what happened with Alec Baldwin last week, put a 2 in the chat, please. I just want to get an idea of what you guys know and don't know. I also did not cover the Hannah Gutierrez Reed trial either, so I'm not going to pretend that I know everything about the case. But it started last Tuesday, the trial. Alec Baldwin was on trial for the shooting death of Helena Hutchins, which happened on the set of Rust in 2021. He was an actor. He was also a producer in that movie. There was no question about whether he was holding the gun when it went off. So unlike Karen Reed, there was proof that he had this gun in his hand and that the gun led to Helena Hutchins' death. There was no question about that. In the Karen Reed case, there's a big question about whether Officer O'Keefe was struck by her car and whether the car accident was the cause of his death. So the poll is 1 if you did follow the Alec Baldwin case. What a difference a judge makes, Granny Go-Go. You know it. Number 2 is if you didn't know anything about Alec Baldwin and you were wondering what the heck happened on Friday when the case was dismissed. David, that's an excellent question, and I'm going to bring that up. So good. I'm glad you put that in there, because when I bring it up, it's going to remind me of where we're going to go next. So during the course of the testimony in the Alec Baldwin case last week, it became evident that the prosecution had withheld some evidence from the defense. And that, as you may or may not know, is what they call a Brady violation. The trial started Tuesday, right? Tuesday the 9th. By the 11th, the defense for Alex Baldwin, led by Alex Spiro of Quinn Emanuel, which is a major, major, major law firm in New York and LA, filed a motion for dismissal and sanctions under Brady, Giglio, and Rule 5501 NMRA. And I want to take a look at the motion because that's what we do here. We look at documents and we have receipts and we go through them together so that you'll have a better idea about what was on paper. Because if you were following this trial live, you may not have had an opportunity to read the motion, and it sheds light on what they were arguing about and why this was so important. Come on, format for me. Format for me. Okay, so this was filed by the defense on Thursday, the 11th. Thursday was the 11th, right? Just let me check my Thursday the 11th at 7:52 p.m. So they ran out of court and went back to their hotel or wherever they were staying because they're from New York. Trial was in Santa Fe, New Mexico. and got this filed by 8 p.m. And here we go. This is the state of New Mexico versus Alexander Ray Baldwin III, RAE. He's a Long Island guy. He grew up in Massapequa with his brothers. And in fact, one of his brothers, I think it was Billy, graduated high school with Rex Heuermann, the suspected Long Island serial killer. So that's an interesting connection to Long Island. This is defendant Alec Baldwin's expedited motion for dismissal and sanctions under Brady, Giglio, and Rule 5501 of the New Mexico Rules of New Mexico, RA. And it's concise and it's to the point, and I like this legal writing a lot. We've seen a lot of legal writing in a lot of different cases that is a word salad and never gets to the point and has very circular reasoning in it. And I find this to be very concise, very to the point, and very easy to comprehend. So let me know what you think. Background: from the moment they arrived on the scene at Bonanza Creek Ranch on October 21st of 2021, law enforcement officers focused almost exclusively on a single question: how did live ammunition end up on a movie set where the presence of live ammunition is, in the words of prosecutors, incomprehensible? But the Santa Fe Sheriff's Office, that's SFSO, and the state have concealed from Baldwin that there was evidence that the live round came from Seth Kenny, a known person of interest and supplier of ammunition to the Rust set. Specifically, immediately after Gutierrez Reed's trial, Troy Teskey, a retired police officer and judge pro tempore in Mojave County, Arizona, delivered a collection of live ammunition to the Santa Fe Sheriff's Office, where they were accepted by CST Marissa Popple. The state had been aware and had access to Teskey for years. Seth Kenny called Teskey during a November 1, 2021 interview with then Detective Alexandria Hancock, after which Teskey sent a picture of sampling of ammunition that did not match the rounds on set. That image was passed from Kenny to Hancock, and there was no further recorded follow-up. In a November 2nd, 2023 pretrial interview of Teskey, the rounds were again discussed, this time with Special Prosecutor Morrissey. I'm going to break just to say that it is so whack that there's a Morrissey in the Rust case, in the Alec Baldwin case, and also the DA in Karen Reed's case is also named Morrissey. So they're both prosecutors. One of them is a special prosecutor in this case, but Michael Morrissey is the DA and lead prosecutor. He didn't try the case in Norfolk County, Massachusetts, in the Karen Reed case. Kind of weird. During the interview, Morrissey specifically asked if Teskey would give her the ammunition from the batch that Reed and Kenny had used to source their live ammunition for the Texas movie set. See Exhibit A, Teskey's pretrial interview, I guess that means. Teskey, who at the time did not know if the ammunition would match the round that killed Hutchins, agreed to provide it, and Morrissey closed out her interview stating that she would work with law enforcement to collect it. The implication of which was that if she ever got the evidence, she would turn it over to Baldwin. Morrissey never followed up, and the state elected to not retrieve the rounds, even though Teskey had told the state that they could retrieve them at any time. The trial of Gutierrez Reed went forward, and at its conclusion on March 6 of 2024, Teskey delivered the collection of rounds to Popple, where it was taken into the custody of the state by Popple and her supervisor, Lieutenant Brian Brandel. The evidence, however, was not inventoried to the Rust case. Instead, at Brandel's instruction, Popple was told to log it as documented information rather than physical evidence. And she was told to log it under a different case file so that it would never be disclosed to the defense. Teskey told Popple that among the rounds that SFSO took into its inventory and logged under a different case number are Starline brass casings with nickel primers, matching the live bullet that killed Hutchins. SFSO's knowledge and possession of the rounds were not disclosed in supplemental disclosures, nor were they presented when the defense requested to view all ballistics evidence at an evidence viewing on April 16th of 2024. According to the testimony of CST Popple, they were tagged with an independent number unaffiliated with the Rust investigation. These facts were elicited on cross-examination after Popple had unequivocally testified that all of the evidence that had been collected in the case had been inventoried, was stored in the vault at the SFSO station, and could be brought into court at any time. Popple also admitted that SFSO prepared a supplemental report about this evidence, which also was never disclosed to the defense. Does any of this sound familiar to any of you? Reports not being turned over, reports being altered, police reports being handed over to the defense that are supposed to be identical reports that were already turned over to the defense, but have different phone numbers on them and different photos attached to them. So all of this was discovered during Popple's testimony, which was that day that this motion was filed, which was last Thursday. On redirect, Morrissey immediately demonstrated her familiarity with the above facts, reminded Popple of Teskey's name, and sought to help Popple reframe her cover-up as an ordinary investigative decision. Argument. The state affirmatively concealed evidence potentially pointing to an external source of the live ammunition, Seth Kenney, because the evidence would be favorable to Baldwin. The remedy for the state's misconduct should be dismissal. Baldwin was unaware of a risk that live ammunition had been brought to the set of Rust. To support its theory that Baldwin should have known of that risk, the state is attempting to establish a link between Baldwin and the source of the live ammunition. The only way it can do that is by demonstrating that the live rounds were brought to the set by the movie's armorer, given the state's assertion that Baldwin should have been aware of her youth and inexperience, and therefore the possibility that she brought live rounds to the set. Evidence that the live rounds came from Kenney is therefore favorable to Baldwin, which is why the state buried it. The state not only failed to disclose the evidence, it affirmatively hid it under a file number that is unaffiliated with the Rust case, and then failed to disclose the only documentation that it claims to have created that would have alerted Baldwin to the existence of the evidence. Simply put, the state was provided highly exculpatory evidence that supports Baldwin's argument of intervening cause. It also supports Baldwin's case that the SFSO's investigation was biased, improperly motivated, and incompetent, which the court has already ruled is relevant and admissible. I'm going to break from the document to say that sounds exactly like what in the Karen Reed case? The Bowden defense. The Bowden defense that the investigation of the murder of Officer John O'Keefe was so biased and so incompetent and so improperly motivated that they never looked at any other suspects. They wanted to pin it on Karen Reed within the same day. And that's what they did. And that's what the defense is arguing in Baldwin. Back to the document. Yet the state concealed that evidence from Baldwin, and then it misrepresented the evidence that it had collected. This conduct is egregious and requires dismissal. And then they cite a case of Davidson and Giglio. In Giglio, they cite for the proposition of whether the non-disclosure of a result of negligence or design, it is the responsibility of the prosecutor to turn over evidence. The state has unilaterally withheld evidence favorable to Baldwin's defense, including evidence dealing with credibility that could be expected to have a significant impact on the jury, while failing to provide any, quote, reasonable explanation, end quote, for its non-disclosure. This is going to come up when we shift to Karen Reed and we start talking about that inverted Sallyport video. I think you know where I'm going with that. Back to the document. Even if the state's failures had been unintentional, which is unlikely, they have been caused by the state's own intransigence in refusing to facilitate Baldwin's access to the discovery he's entitled to. Quoting State v. Harper, which the judge is going to quote again in her ruling, and are at a minimum sufficiently reckless to warrant dismissal. This information was required to be disclosed under Brady, Giglio, and Rule 5501 of the New Mexico Rules of NMRA. The state has repeatedly violated its obligations under these principles and rules. And again, going back to Karen Reed, repeatedly violating court orders to turn over discovery. Repeatedly. We watched many, many hearings where as far ago as March of 2023, the defense was still arguing to try and get basic discovery that they were already in violation of not turning over. Basic stuff. In the alternative, Baldwin is also entitled to an adverse inference instruction that the state concealed this evidence because it knew it would be favorable to Baldwin's defense. Under this remedy, the court should instruct the jury that it must disregard Popple's testimony that the live rounds from the Rust set did not match the live rounds that Teskey delivered to Santa Fe Sheriff's Office. Conclusion, the court should dismiss the case with prejudice, or in the alternative, issue an adverse inference instruction and inform the jury that it is striking Popple's testimony. XOXO Quinn Emanuel by Alec Spiro. So they're asking for alternative remedies here. They're asking for, number one, judge, you should absolutely dismiss the case, which is rarely ever granted, my friends. Rarely. What you saw on Friday is crazy. Or in the alternative, you should give the jury or charge the jury with an adverse inference instruction that they can draw an adverse inference from the fact that this stuff was not turned over to them. And I can't recall, maybe one of you can remind me, during the motions in lemonade, as we came to call them in the Reed trial, because that's what the closed captions called them one day, or even during trial, during the charging conference, whether the defense ever argued for an adverse inference instruction with regard to anything like the inverted Sallyport video, like the whereabouts of Chloe, like the way the Canton Department of Public Works records were not turned over, or that the DPW tried to tell the defense that it was a contracted person who plowed that night and not Lucky Loughran. So many things that went wrong in Reed. Thank you, Lorelei360, for the win for giving 10 memberships. You're so kind and generous to this channel always. And also thanking me for all I do for these cases. Listen, there are parallels that need to be drawn. Melly, listen, I didn't set it up yet, but I think at 4 p.m. Eastern, I'm going to do a stream today on Nikki McCain. So I'm going to set that up. I'll redirect everyone from here to there, because Nikki McCain is still missing in Northern California. She's a mother of 4. It's devastating. Somebody has to find her. And her husband had domestic violence charges against her that were dismissed because she didn't show up. And then he set a fire, and there was a major wildfire that he's on the hook for, that they say he started. It's a wild case. So Melly, make sure you tune in for that later, because I know you live near there. David, we're going to get to this later. Thank you. Melly, thank you. Happy Monday to you as well. Wonderful, Melly. And thank you on top. Nina, I will get to your question as soon as we watch what happened in court on Baldwin. So this motion was filed on paper, and then it was wild. Then they had a hearing outside the presence of the jury, and the prosecutor called herself, the special prosecutor, this Carrie Marcy, called herself as a witness and got up on the stand and testified. And I think if I could find that, that would be really great to play. So let me just see if I can find that, because it was wild. They were telling her, no, we don't need your testimony. And she said, oh no, I want to testify. It was crazy. And I think she might have buried herself. Okay. So she wanted to get up there and explain herself. So I'm going to put it on a little bit faster speed, but this was wild. And if you haven't seen this, you should, because then you'll know what the water cooler conversation is about. Do we even have water cooler conversations anymore? Does anybody go to an office anymore? Ever? You know what I'm talking about. Everybody's talking about it, so you want to be in on it too. Here's the moment where she got up to testify. It was crazy. I've never seen anything like this before. Let me know that you can hear it.
All right, Ms. Morrissey voluntarily calling herself as a witness without any requirement by the court to do so, or Mr. Spiro asking her to. Please raise your right hand. Do you swear affirm under penalty of law that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
So she wants to defend herself for not turning over this potentially exculpatory evidence. And remember that under Brady, it doesn't have to be exculpatory evidence. It can be impeachment evidence. It could be lots of different types of evidence, but she's going to try and talk her way out of it. And in my opinion, I think, yeah, act of desperation, right? That testimony, like it was, she didn't think about it long enough and she just got up there and was trying to save herself. She could have just let the judge rule on the motion instead of implicating herself in potential ethical violations that could cause her to be reprimanded by the state bar. I don't think it was a smart idea at all. All right, I'm going to just speed this up just a little tiny bit. If she talks too fast, let me know, but this is crazy. She's explaining away her failure to turn over this evidence to the defense.
During my investigation of this case and my review of the evidence in this case, I came to understand that there was a large batch of live ammunition that was in the possession of Thel Reed, Hannah Gutierrez's father. I also understood from all of the evidence and testimony that a portion of that batch of ammunition that belonged to Thel Reed was taken by Thel Reed and Seth Kinney to the 1883 Cowboy Training Camp. When that was over, leftover ammunition was taken back to PDQ Props. Seth Kinney took some of the ammunition from that container that he had brought back from Texas and turned it into the sheriff's department. And it appeared to me that he did it to try to exonerate himself. They took it from Mr. Kinney and they tagged it into evidence under the Rust case. Law enforcement then executed a search warrant at PDQ Props and they took the entire container. And I will say that I do agree, as I recall, although I don't.
I just want to rewind it to look at Hilaria's face. She is not having any of it. I got to give her like some props. Like the way she handled herself during this trial. First of all, she's gorgeous. Second of all, she came into court every day looking gorgeous. And she just seemed like she was such a rock for her husband. Like no matter how you feel about Alec Baldwin, a lot of people don't like Alec Baldwin for whatever reason, his politics, whatever. A lot of people think he's a jerk. I think he's very lucky to have a wife who sticks by him like that. They have 7 kids together too. But anyway, that's my opinion of Hilaria, but she looks pretty mad. And wouldn't you be too?
That I do agree, as I recall, although I don't have it in front of me, I do agree that the search warrant didn't really require law enforcement to take everything, but it was my understanding that Mr. Kinney gave them everything so that they would have it and could tag it into evidence. Portions of that ammunition were then sent to the FBI for testing so that they could be compared to the live rounds that were found on the set of Rust. The FBI testing demonstrated that the live rounds that were taken from PDQ Props that were originally in Texas did not match the live rounds on the set of Rust. And that's testimony that we heard during the Gutierrez trial. So what ended up happening was Mr. Bowles, Ms. Gutierrez.
Here's the thing though, too. Didn't they know about this evidence before the Gutierrez Reed trial? And someone pointed out too, isn't it odd that her name is Reed? Karen's last name is Reed. Like the parallels are just weird. So they could potentially overturn Hannah Gutierrez Reed's conviction. We'll see what happens next with that, but this is wild.
His lawyer put Mr. Teskey on a witness list and was intending to call him as a witness to the Gutierrez trial. I conducted a pretrial interview of Mr. Teskey, and I want to back up. I did at this point have some understanding that Mr. Teskey had had contact with law enforcement regarding these rounds that he still had in Arizona. So these are rounds that never left Arizona. They were always in the possession of Thel Reed and Troy Teskey. They never went to Texas. They never came to New Mexico. That's what all of the evidence indicated. So I understood that Detective Hancock had communication with Mr. Teskey about trying to get those rounds, and Detective Hancock was unable to get those rounds from Mr. Teskey. I did not find that particularly concerning because those rounds had never left Arizona. The filming of Rust was in the state of New Mexico.
She never, ever should have gotten up there and given all this information away, because she's only solidifying the fact that she knew all about this, and she's determining whether or not it's relevant. And that's not her job. As Jane Gardner points out, Morrissey decided that she should be the determiner of fact, not the jury. That's not her role. And this is a problem for her ethically. You don't get to decide that, ma'am.
And the rounds that were taken from PDQ went from Arizona to Texas to Albuquerque. So ammunition that is in the state of Arizona that has never left Arizona did not strike me that it had significant evidentiary value. Then, and I will say, I believe I actually saw a photo of it. At that point in time, I was able to look at the ammunition myself, and it was visibly dissimilar than the rounds from the set of Rust.
And based on that photograph, that's what she assumed that he brought in. It turned out it wasn't what was in the picture. She made a lot of assumptions here, and she didn't do her basic duties, but that's coming up next.
We then cut to November of 2023. Mr. Bowles has put Mr. Teskey on a witness list for the Hannah Gutierrez case. We conducted a pretrial interview with Mr. Teskey on November 2nd of 2023. At that point in time, he brought up that he was still in possession of these live rounds that were Thel Reed's live rounds that had never left the state of Arizona. I then, when he started, I think he indicated during the pretrial interview that they were from the same batch that was sourced from Joe Swanson. And I then said, we should get those from you. I had a conversation with Detective Hancock after that pretrial interview about how we could get the rounds from Mr. Teskey, and we were trying to figure out if we could send a local law enforcement agency to pick them up. I was then decided that I needed to figure out if that was necessary, since they had never left Arizona. And up to that point, it was my impression that they did not match the live rounds from the set of Rust. I then, as I recall, reached out to Mr. Bowles. He and I had a conversation.
Look at his face. He's just like, I cannot believe that you're doing this. Look at Hilaria's face. She's like, I cannot believe what's happening. Like, she gets it. And Alec is kind of like, he's probably just so spun. He really doesn't understand the gravity of this. And you'll see like his facial expressions when the judge starts making her ruling. He's kind of confused. Like, he doesn't really understand what's going on, but she gets it.
About whether or not the rounds should be tested by the FBI. And I was still trying to figure out if I could get the rounds from Arizona to New Mexico. So I asked Mr. Bowles to please send me a photograph of the rounds from Troy Teskey so that I could see with my eyes whether they were even remotely similar. If they were similar, I could go through the steps of obtaining the ammunition, connecting probably with local law enforcement, having a local law enforcement agency go to Mr. Teskey's residence and collect them. I didn't want to do that if they didn't look anything like the rounds from the set of Rust, because all 6 rounds from the set of Rust are identical to each other. So when I had this conversation with Mr. Bowles, he provided me the photograph that I showed this morning. And this is it was my understanding that this was a photograph from Troy Teskey. So Troy and I don't communicate. He's a defense witness. I can't communicate with a defense witness. So Mr. Bowles, as I recall, texted me this photo, and this is a photo that Mr. Teskey took at my request so that I could determine whether this ammunition was related in any way to the set of Rust, because it never left the state of Arizona. So if it never left the state of Arizona, the only way that it is relevant to The Rust investigation is if it has any similarity to the live rounds that were found on the set of Rust, because we were at that point trying to figure out the source of the live rounds. When I received this photograph from Mr. Bowles, I could immediately tell that these are very dissimilar from the live rounds that were found on the set of Rust. They have brass primers. So this is what was presented to the prosecution as the rounds that were in Mr. Teskey's possession. They have brass primers and not silver primers. One of them, the one on the left, appears to be a Starline brass casing, but they have truncated cone projectiles. We had seen ammunition that looked exactly like this, not exactly, but very, very similar. And that ammunition was the ammunition that was collected from the sheriff's department and went to the FBI for testing and was determined not to be similar in any way to the live rounds on the set of Rust. So when I saw this photograph, I could see that it was not at all similar to the live rounds on the set of Rust. And I decided not to take any steps to collect this ammunition because it was in Arizona, had never come to New Mexico, and didn't match the live rounds on the set of Rust.
Thank you, Bentley. Bentley says, ma'am, testing should have been done to disprove the match, not your dang eyes.
So what ends up happening is Mr. Teskey is called to New Mexico by Mr. Bowles to testify at the Gutierrez trial. And you can hear on the video that the court heard Mr. Teskey say, the defense attorney, that's not me, asked him to bring samples of that ammunition. According to Mr. Teskey, he brought the samples of the ammunition, showed them to the defense attorney, and the defense attorney said, I don't want those. I'm not going to use those. And by the way, I'm not going to call you as a witness. So Mr. Teskey sat in court during the trial, and then at some point contacted the deputies downstairs and said, I have this ammunition. So he tried to give it to the defense attorney, who's the person who asked him to bring it. The defense attorney said no. And he then tried to get a hold of Detective Hancock, who was not available because she was with me. So
She's got like a whole lot of abra word salad. Like she's really trying too hard. Really, really trying too hard to defend herself now.
So then he ends up going to the sheriff's department and he leaves the ammunition at the sheriff's department. I was contacted, I don't think it was the same day, but I'm not 100% sure. It's possible that it was, by Detective Hancock, and she indicated that Troy Teskey had dropped off ammunition at the sheriff's department. Because I had already asked for a photograph of it, I believed that that ammunition was going to look like the photograph that Mr. Bowles had sent me.
Ah, you know what they said on The Odd Couple? You should never assume. Because when you assume, you make an ass out of you and me. Mostly you.
Corporal Hancock indicated that she was going to tag them into evidence and she was going to create what she called a doc report. And I said, great, do that. I was not aware at that point in time that a doc report would not have the same case number as Rust. I was not aware at that point in time that it would not be linked to the Rust case number. I understood that he had dropped off ammunition that I believed to not look similar to the ammunition from the set of Rust. And I had no idea that it wasn't going to have the same case number. I want to
Guess what? It's your job to know, though. It is your job to know. See if she was playing with her ear right there? What did the body language experts say about that?
show the court, though, when Mr. Teskey showed up to testify with the ammunition that Mr. Bowles told him to bring to the state of New Mexico, he was not called as a witness, And Mr. Bowles said, I'm not taking that ammunition from you.
Okay, so what? That's a different trial, ma'am.
That's why. Because these are photographs from Hannah Gutierrez's cell phone extraction, and they show spot on match for the live rounds found on the set of Rust. This is clearly the reason that Mr. Bowles said, you and your ammunition better get out of here, because it would not have hurt the case, the state's case against Hannah Gutierrez. It would have been the best evidence I could have hoped for.
Okay, and so what? This is a different trial against a different defendant who's got different theories of his defense, including sabotage, by the way. You know what another word for sabotage is? Being framed. Very similar to the Karen Reed case.
These are
Oh, members, can I have some shovel emojis in the chat? Because she's really digging herself. She's really, really digging herself in a hole. I can't believe she did this. People who think they are the smartest person in the room, like somebody said before, the lawyer who represents herself has a fool for a client.
these look exactly like the ammunition, the actual ammunition that we have in evidence. And they do look like the 3 rounds that are in that envelope. So when Mr. Teskey couldn't get Mr. Bowles to take them because they were the best evidence against his client, he took them over to the sheriff's department. And when he dropped them at the sheriff's department, I was told that there was going to be a report. There was a report. I assumed they look like these. And Detective Hancock indicated to me that because he dropped them off and he didn't wait for her, she was then going to try to follow up with him, take a statement.
Again, his face is like, I can't
Drop
believe,
them off, and he didn't wait for her. She
I cannot believe what you're doing to yourself right now. I cannot believe what you're doing to yourself right now.
was then going to try to follow up with him, take a statement.
When I say sabotage, somebody says sabotage. How did she sabotage Baldwin's failure to handle a firearm properly? No, they were going to claim that the set was sabotaged by somebody putting or getting live ammunition to that set. That it was not Hannah Gutierrez Reed who brought the bullets or the ammo or the rounds to set. It was this guy, Seth Kenny, who had a beef of some sort. So that's what I think part of his defense was going to be, or could have been. But as you'll see the judge say in her decision, it doesn't matter. Because what they did was so egregious it warranted dismissal of the case. So hang on.
From him so that we could get some idea where they came from, what the relevance was, if there was any relevance at all. And he never returned her phone calls. And that's all of the information that I can give the court, but I'm happy to answer any questions.
So you don't follow up. He never returned her phone calls. You don't follow up. You don't see if a report was ever filed. It was under a different case number, so you never saw it. You didn't think, look at her. There's an expression that they talk about a lot on these body language channels. Okay. Go with that.
May I ask a few questions, Ron? When you took over this case, the investigator handling the case, Mr. Schilling, left the case, correct?
At my request, yes.
The paralegal that was handling this case with you left the case, Mr. Todd.
At my request, yes.
Well, the first prosecutor that was working with you on this case, you selected, correct?
I did.
And he resigned too?
I wouldn't say that he resigned, no.
He didn't stay on the case for the Alec Baldwin trial, correct?
No, and he indicated that that was because he represented a labor union that's a national labor union, and he was not expecting the trial to be set so quickly. He wasn't expecting it to be set in July. So when he realized that the trial was going to be set in July, he was going to be in collective bargaining agreements for his national labor union, and he wasn't going to be able to have enough time.
Erlinda Johnson, the next prosecutor selected, resigned from the case today,
She did.
based in part.
And that was wild. That was like a bombshell that Erlinda Johnson, who was the other special prosecutor on this case, resigned that exact same day. Nobody knew that. This was a bombshell drop during this hearing. She gave an interview afterwards, and she was like, and it was because of this Brady violation, because they didn't turn over this evidence. That's why she's like, I couldn't continue representing the prosecution in this case after what I found out had happened.
Hard on the conduct we're here discussing, correct?
I believe that Ms. Johnson Ms. Johnson didn't want my understanding is that she didn't agree with the decision to have a public hearing.
On July 1st in this matter, you served a certificate of compliance with 5501, correct?
I did.
And you've never turned over the report or any of the evidence that we're talking about here at this hearing, correct?
Let's take it one at a time.
Now she's telling him how to ask his questions. Oh, you gotta love the arrogance, huh? You gotta love the arrogance here.
I did not turn over the report. I didn't have a copy of the report. The rounds that were left at the Sheriff's Department by Troy Teskey, I have absolutely no reason to believe that they are relevant to the incident that took place on the set of Rust. These are rounds that were in the possession of Thel Reed and never left the state of Arizona.
You also did not allow the defense to view that evidence at any point during our request to review evidence in this case.
I had never seen it, and I didn't realize that it wasn't under the same case number because I'm not a law enforcement officer and I don't work at the Sheriff's Department. But you are.
Again, ignorance is no defense, ma'am. This is your case. You should be aware of everything going on in this case. Everything.
All right.
And you can see that they are Starline brass, silver 45, right?
I can. And this is the best evidence against Hannah Gutierrez.
Yeah, you've said that a couple of times. Any favorable evidence you understand as a prosecutor?
Yeah, you said that a couple of times. I love that. Just like, just keep digging. Dig, dig, dig.
Has to be turned over to the defense, correct?
I do.
Any evidence that could be used as a defense to potentially be favorable has to be turned over to the defense.
Absolutely.
So the third Hague report that never got turned over to the defense, you understand that that's Brady evidence?
I did, yes.
Okay. And you also failed to turn that over in this case as well, correct?
And let me give you a full answer to your question. When the second Hague report came in, and I provided all of this to the defense, I sent it to the person who is managing the discovery server and asked them to upload it. It wasn't until I realized during pretrial interviews that it wasn't there, that there was a problem with it. So I then attempted to figure out what the problem was, and it was indicated to me that it appeared that the former paralegal who was working for the special prosecutor had removed it. So we then immediately provided it. Then during the pretrial interview of Mr. Hague, it was brought to my attention that the defense did not have the August 31st report that indicated that the gun functioned fine, perfectly fine. And that was provided immediately. I went back, I checked my email. I could see that I received it from Mr. Hague and failed to forward it on to be uploaded. And I provided it as soon as I was aware that you did not have it.
The fact that nobody at the Hannah Gutierrez retrial cross-examined Mr. Hague about the report didn't clue you into the fact that nobody had the report?
Actually, it didn't, and I'd like to address that. The reason that it didn't clue me in is because Hannah Gutierrez's defense was that the gun worked perfectly. The defense in Hannah Gutierrez was never interested in any evidence that there was an issue with the gun, because if there was an issue with the gun, it damaged her case. So what you could see, if you watched the trial or saw any of the transcripts, the defense actually brought in their own expert to say that the gun worked perfectly. So they had no interest in that information.
And actually, you elicited testimony from Mr. Hague at that trial that was inconsistent, at least partially inconsistent, as the court's aware, with his third report, correct?
Tell me what you're referring to, and I'll answer your question.
Well, there was a whole hearing about this where you saw this, and you saw me go back and forth with Mr. Hague for 25 minutes. So
I agree, but I need to know what you're talking about for me to answer your question.
Okay, if you can't answer the question, you can't answer the question. I'll move on.
I'm happy to, but
You say that
Like, she's not fooling
the extent of the
anybody.
communications you have about the doc report, as you relay it to the court, is that all you said in response was, "Great, do that." That's your testimony?
yeah, I assumed that it was going to be tied to the same case number. So I said, great, do it, file a report.
No follow-up
Don't assume. Don't assume.
questions?
No, because I had a picture of the ammunition that didn't match the ammunition from the set of Rust.
No concerns in your mind when you got the case file and you turned it over to us and it wasn't included?
Absolutely not. There's a terabyte of discovery. I didn't know whether this 2-page police report had been provided. And in addition to that,
Oh, wow. That is really weak. We gave you a whole terabyte. We gave you so much stuff. How should I know that there's a 2-page report missing? I mean, we gave you a whole terabyte of stuff. So 2 pages was missing. That could be exculpatory, maybe, perhaps. No big whoop. Wow.
I had no reason to believe, and still have no reason to believe, that those rounds have anything to do with these cases.
It doesn't
As I
matter.
asked you about Mr. Haig yesterday when Ms. Popple testified, you would agree with me that her testimony under oath was false.
What part of her testimony was false? And I'll answer.
That she said that these rounds don't look anything like the rounds on the set when you elicited that testimony.
I agree with you, and I didn't realize that there were rounds that looked like that.
It's okay.
Mm.
In any event, when the court, and you never tested those rounds either, correct?
Again, it's like the Shaggy defense. It wasn't me. It wasn't me. It wasn't me. That's not going to play well in front of the Bar Association.
Any of the rounds that came from Mr. Teskey? No, because they came in just a few months ago.
And the court asked you actually one question that I want to address, which is the court said to you, well, what's interesting to me, to be quite honest, is that yesterday you didn't even want to do a written reply. You wanted to just give an oral response. And what you said to the court was, I never saw these. I've never seen these. And I never saw the report. I have absolutely never seen these until this morning. Do you remember saying that to the court?
With regard to the 3 Starline brass, with regard to the 3 cartridges that appear to be similar to rust, yes.
Well,
I never saw them until today.
Well, but you said also, I never saw the report, right?
I never did.
Right. But don't you think, given your duty of candor to this court, that that's awfully misleading to not tell the court at that point that you knew about this when it occurred long ago?
That I knew about what?
You knew that Mr. Teskey had turned in this evidence, that you knew that the report would have existed because you just told this court that the doc report was okayed by you.
Sure.
Don't you think it was misleading to this court to not just say at that point, you know, just so you know, I know about this. I knew about this then. I was involved.
I did not intend to mislead the court.
Mm.
My understanding of what was dropped off at the sheriff's department is on this computer screen, and it looks absolutely nothing like the live rounds from the set of Rust.
Except it wasn't what he brought to the station. It wasn't. That was a picture you got a long time before that. It wasn't. And the fact that she keeps trying to double down on defending herself is crazy. Deb Wagner says she wanted the outcome she wanted, and that was that.
The truth of this matter is you don't like Mr. Baldwin very much, do you?
Oh, this is
You know,
fantastic,
that
but
is
hold on. I'm going to have to bleep a
absolutely
part of it out.
True. I actually really appreciate Mr. Baldwin's movies. I really appreciated the acting that he did on Saturday Night Live, and I really appreciate his politics.
Really appreciates his politics. Okay, the next thing he's going to say, I'm going to bleep out when he says it. You're going to have to guess what it is. Okay, ready?
You told one of the witnesses who disagreed with you during an interview that you thought Mr. Baldwin was a...
In case you didn't get that. I have to bleep it. Otherwise, YouTube is going to strike it. I'm sure they struck everybody's stream that day. Isn't it true that you said Mr. Baldwin was a sea sucker? Can you hear that? Can you hear Mr. T's keychain say don't make me mad? I think I have to hold it away from the keychain for you to hear it. Maybe from the mic. Isn't it true that you called him that?
Do not recall saying that. I know that that was something that Mr. Baldwin would say on the set of Rust. I
Wow.
don't recall saying that.
Can you
deny that
believe?
under oath?
Can you believe? I believe that's something that he would say. Like she turns it right around on him. That he would say that.
Without having more information, I can tell you that I do not recall ever saying that. And if I did say it, I invite you to point it out to me.
I don't remember.
You called him an arrogant
I
prick
don't
to
recall.
another witness.
To who? To what witness?
I'm asking you, did you call him an arrogant prick during a witness interview?
I don't believe I did. I don't recall.
Yeah. She wants receipts or she's not going to admit it. Yeah, like a 5-year-old. Wow. Like, do we need to bring someone in to testify now that you did say that about him? Because you don't like him. And you know what the problem with that is, ma'am? It shows bias. Shows prosecutorial bias.
You deny that.
Without knowing what you're talking about, all I can tell you is that I can't respond if I don't know what you're talking about.
And you said also to witnesses that you would teach him a lesson.
I never said to witnesses that I would teach him a lesson. Absolutely not. In fact, Mr. Spiro, I want to give a full response to your question.
Oh man, that's the least of
I
your
made
problems.
every effort.
That's the least of your problems. Saying that you wanted to teach him a lesson. Now this is very inappropriate what she says next.
In this case, to resolve this case with your client in a very favorable way for him.
All right, I'm going to move to.
You're not allowed to talk about plea deals in a situation like this for the cameras. Ma'am, that's right, Pilgrim Shadow. The dire wolf collects his dues. That's a Grateful Dead reference. Don't murder me. I beg of you, don't murder me. See what you're doing there. See, I'm picking up what you're laying down, Pilgrim Shade. Thanks for the 5 spot. Yep. Yep. Big time Jen McCabe vibes here, says Danielle. This sounds so political to me, says Dana Town. Oh, Lordy. Hello, Princess Mish. So nice to see you, one of my amazing moderators. Bentley says, ma'am, you talking about a plea deal right now? Looks awful. Yes, 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 it does. Doesn't matter what evidence I hid. Doesn't matter what I said about him to people that I don't remember saying it to, like calling him a something sucker and a arrogant prick, and calling him, saying I was going to teach him a lesson because you know what? I offered him a really good plea deal. Wow, just she doesn't know when to shut up. I'm playing grab ass. Loving you guys change your screen names to match the trials. That's a Karen Reed reference about Brian Higgins and Brian Albert playing grab ass at the waterfall.
To strike this, it's not responsive.
It is
Well, I don't
responsive.
want to talk about plea negotiations.
Yeah, and it's not responsive. So I have no further
All right, do you have any follow-up testimony?
Let's keep the chat classy,
Right.
please.
I want to say I have no recollection of calling him any of those names. I have invited the defendant to tell me what he's talking about, and he has declined. I want the court to take notice of that.
He's not the defendant,
Thank you.
ma'am. He's the actual defense attorney. So there's that. He's not the defendant. But you probably know that. So that was wild. And if you didn't see that, you might have been blown away by it a little bit. Also to find out that the other special prosecutor had resigned that exact day. That was crazy. Let's take some questions and then we're going to take a look at the judge's ruling. And she rules from the bench, which is something that I admire greatly because we watched Beverly Cannoni never rule from the bench on practically anything during the Karen Reed pretrial and trial. And everything that was done during sidebars that we did not get to hear. So when I play back some of the portions of Buchanan's testimony, when that inverted Sallyport video was shown to the jury and us and the world, we're going to see an objection. And we're going to see they go to sidebar and we're going to see that objection overruled. And I kind of think that was a major problem in many ways. Thanks, Mel Clamp for the 5. Super sticker. Paula wants to know, why do you think she chose to testify? To save her ass. She chose to testify to save her ass. This was what you call a Hail Mary. To save her case, to save her ass, and to try and get the judge to perhaps pick the least restrictive method, punishing the prosecution by giving an adverse instruction to the jury when the jury got the case. Didn't work out. Thanks, Ruby, so much for your time. The hubris. She thought she could brass balls her way out. Erlinda saw what was happening and quit. For Erlinda's ethics, I think that's an applause sign. If Carrie asked for dismissal, she could have gotten it without prejudice. Perhaps. Hubris. It's great. Nina wants to know if Hannah's conviction could be overturned now. It might. It might. I don't know. She seemed to testify that her lawyer knew about these rounds, so I'm not sure. I'm not familiar enough with that case to opine. However, I did read some articles and some other talking heads said that it could be enough to get her case overturned, but she's sentenced to 18 months, right? She's already been in there since March. She's already been in there for 4 months, I think. Correct me if I'm wrong. But by the time this gets heard, who knows, unless they hear it on an emergency basis. Robert, thanks for tuning in from Canada. Did the defense know about this issue, but waited until double jeopardy attached to address it? R.I.P. Jerry, Pigpen, Brent, and Vince. Oh, I was listening to a Brent show the other night. I really miss Brent a lot. I mean, and Jerry, everybody. But another Grateful Dead reference. I don't know. I don't know if they knew about it or if they were surprised about it when it came out on the stand with that witness. I'm not really sure. I think some people have pointed out that the questioning led them to believe that he knew about it. I'm not quite sure. I can't answer that, Robert. But if anybody in the chat knows for sure, you can let me know if he's spoken out about it. Nina says everything she said after 10 a.m. was not believable at this point. Thanks, Nina, for the 5. Bruni Saint, thank you for tuning in from Australia. When the law acts unlawfully, all people of the country are in trouble. That's right. That's right. Lady in Boston loves mid-morning Melanie. Thank you. I've had just enough coffee. Thanks for the 2. Appreciate it. Reality Check said Sergio is released today. Released a movie today on the case? What? Oh, Sergio, whose stuff I played, Truth Revealed. Is that his channel? The guy whose stuff I played the other day? Mm-hmm. Sergio De Niro. Awesome. Thank you. We'll all take a look for that later. I suggest everyone take a look for that later. Charlie Lynn gifted 5 memberships. Thank you, thank you, thank you, thank you so much, Charlie Lynn. You're so kind and generous. Herbert Wittard says they brought a witness from Italy but couldn't get evidence from Arizona. Right. She didn't want it because she just assumed from looking at those pictures that had no relevance. She didn't want it. She could have got it. She just didn't want it. And even when it was delivered, she didn't look at it. She assumed it was the same as the picture. A lot of big mistakes there. A lot of big mistakes, Herbert. Thank you so much. Nina, can you explain why the case was dismissed with prejudice and not without? Because jeopardy had already attached. Theoretically, the case could retry with a new jury and get this evidence in. No, not anymore. They can't. But if they wanted to dismiss it without prejudice, they could have and then refile. But hadn't this already been filed a couple times? It was filed initially, then it was dropped, then it was filed again. Diana Miller, thanks for the 10. Late to the live, but so glad I'm here. Love your pleasant insight, Melanie. The Baldwin trial was wild. I was so glad Spyro showed up on Friday when Morrissey stopped interrupting. I really like Johnson. Yeah. All right, let's take a look at the judge's ruling on this case, because this is something you hardly ever see. And this is an amazing judge, in my opinion. Watch Alec Baldwin's reaction. And right after Marcy got off the stand, she just got right into it. I don't even think she took like 5 minutes. She didn't take a break.
All right. So dismissal with prejudice is a very extreme sanction. And case law is very clear that because it's very extreme, I have to go through every single element and I have to make a very good record as to why I'm seeing what I'm seeing. So in order to establish a Brady violation, the defendant must show that the prosecution suppressed evidence, the evidence was favorable to the accused, and the evidence was material to the defense. So let's go through the elements. Suppression of evidence. The definition of suppression of elements, this is Case versus Hatch, is while the first element requires proof that the prosecution suppressed or withheld the evidence in question, it does not require a finding of bad faith or any other culpable state of mind on the part of the prosecutor. This prong is satisfied. The Santa Fe County Sheriff's Office and the prosecution failed to disclose the supplemental report to defense, and provide defense an opportunity to inspect the rounds collected into evidence that Mr. Teskey gave. Is the evidence favorable to the accused? The second Brady element is whether the suppressed evidence was favorable to the accused, either as impeachment or exculpatory evidence. This prong is satisfied. The suppressed evidence is favorable to the accused. It is impeachment evidence, has even been offered in this trial as impeachment evidence, and is potentially exculpatory to the defense. Critically, the exculpatory value cannot be analyzed at such a late juncture because of the non-disclosure. Is the evidence material? While post-trial discovery of evidence under Brady requires a reasonable probability that the result of the proceeding would have been different, discovery of evidence during trial requires an evaluation of whether the late tender has impeded the effective use of evidence in such a way that it impacts the fundamental fairness of the proceedings, and that is State versus Huerta Castro. This evidence is material. The late discovery of this evidence during trial has impeded the effective use of evidence in such a way that it has impacted the fundamental fairness of the proceedings. The defense is not in a position to test the state's theory as to the source of the live rounds that killed Ms. Hutchins. I'm also going to take a look at Harper, State versus Harper.
A lot of people are saying in the chat that they just heard that Carrie Morrissey was disbarred. I very highly doubt that it would happen this quickly. I mean, this happened on Friday. There's no way that they're going to be able to render a decision, and she gets to have a hearing and all kinds of things. So let's not spread information in the chat. I mean, there's just no way that the Bar Association would rule that quickly on something like this. There's a procedure that has to take place. So unless somebody can point to some credible evidence, I'm not going to throw that misinformation out there. There's a process, and she's allowed to be represented by counsel, and it is a whole thing. So while it may happen at some point, it might not. She may be sanctioned. I don't know, but let's just not spread any misinformation in the chat. Thanks. Judge Summer, can you please come to Dedham? We'll buy you a plane ticket.
The assessment of sanctions depends upon the extent of the government's culpability, weighed against the amount of prejudice to the state, quoting Chenard. Let's go through culpability. Our case law generally provides that the refusal to comply with a district court's discovery order only rises to the level of exclusion or dismissal where the state's conduct is especially culpable.
Look at her face.
Such as where evidence is unilaterally withheld by.
Look at her face. She's like, are you seriously going to dismiss this case? I just gave you a whole long explanation about defending myself about why I didn't know anything about this, and it shouldn't be my fault, and you shouldn't dismiss my case because this is going to reflect really poorly on my career. I say this a lot about high profile trials. They can make or break careers. We're seeing that in a lot of cases lately, like such as this one.
By the state in bad faith, or all access to the evidence is precluded by state intransience. The state is highly culpable for its failure to provide this discovery to the defendant. The state unilaterally withheld a supplemental report. Santa Fe County Sheriff's Officer made the decision, and apparently also with the prosecutor, as pursuant to Hancock's testimony, that the evidence was of no evidentiary value and failed to connect the evidence to the instant case. The case agent, as well as pursuant to Hancock's testimony, Ms. Morrissey, was aware of the new evidence and yet did not make an effort to disclose it to defense. The state's willful withholding of this information was intentional and deliberate. If this conduct does not rise to the level of bad faith, it certainly comes so near to bad faith as to show signs of scorching.
Prejudice. Signs of scorching, so near to bad faith. While you're listening to her speak, think about the inverted Sally Port video in Karen Reed. Was that turned over willfully? Was that turned over in bad faith? Because that was turned over on April 24th of 2024, which was during jury selection by the Commonwealth. And that was made Buchanan testified that that was a fair and accurate representation of the Sallyport garage. And we didn't learn until cross-examination that that video was inverted, and none of the other videos from the Sallyport were inverted. So it's not just like the system just did it that way.
When discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defendant's preparation for trial. The court concludes that this conduct is highly prejudicial to the defendant. The jury has been sworn, jeopardy has attached, and this disclosure during the course of trial is so late that it undermines the defendant's preparation for trial. There is no way for the court to right this wrong.
Again, I'm going to point to the Sallyport video. And I think that we're going to watch it, but I think when the judge denies the motion, and we don't really even know what the motion was because everything was done at sidebar, so we have no idea if it was a motion to exclude the Sallyport video, if it was a motion for an adverse instruction, if it was a motion to dismiss the whole case because it was intentionally shown to the jury to mislead the jury. I mean, think about how egregious that is. You want to talk about bad faith?
Lesser sanctions under Harper. Trial courts possess broad discretionary authority to decide what sanction to impose when a discovery order is violated. State versus Lemire. The sanction of dismissal is the only warranted remedy.
He doesn't get
the
it.
Jury has been sworn. Jeopardy has.
He doesn't know. And his attorney's putting his hand on his back like, dude, the case is over. He's in shock and horror. He doesn't get it.
Attached, and a mistrial would not be based upon manifest necessity. Further, the sanction of dismissal is warranted in this case. The state has repeatedly made representations to defense and to the court that they were compliant with all their discovery obligations. Despite their repeated representations, they have continued to fail to disclose critical evidence to the defendant. Brady and Harper are satisfied. Dismissal with prejudice is warranted. Court also has power, inherent power. Per State versus Lemire, where discovery violations inject needless delay into the proceedings, courts may impose meaningful sanctions to effectuate their inherent power and promote efficient judicial administration. The state's discovery violation has injected a needless, incurable delay into the instant jury trial. Dismissal with prejudice is warranted to ensure the integrity of the judicial system and the efficient administration of justice. Your motion to dismiss with prejudice is granted.
And no matter how you feel about Alec Baldwin or how you
Now,
feel
with
about this
respect to the
case or
jury,
what
I don't
he
imagine-
should or should not have done with respect to his handling of that prop firearm on a movie set, and with respect to the rules he may or may not have violated with regard to gun safety, this is what justice looks like. This is what justice looks like. And you cannot withhold evidence from the defense. You just can't. And you can't try and talk your way out of it. And this is not something, I don't even think the defense attorney thought that she was going to dismiss this case. I thought maybe he'd get the curative instruction, and you rarely see it, but this judge was not having any of it. And this is what justice looks like. Just let it play out a few seconds more.
You all want to return on Monday? I will take care of the jury.
Thank you.
We are in recess.
So the jury came back today, or they're going to come back today. It's a couple hours earlier right now in Santa Fe. And they will be dismissed. And I'm sure somebody might have told them that the case was dismissed. And look at the emotion. Like, if it doesn't make you choke up just watching them, I don't care. I don't care about anybody's personal feelings about how they feel about this couple, who also happen to be filming a reality show right now, and they don't speak to the media when they leave the courtroom. So whatever production company got the deal with them for the reality show just tripled their money's worth after this happened. The judge was done with the circus. Yep. No, the judge actually said you don't have to testify. She kind of tried to talk her out of testifying. But womp womp, she was done with the circus. She was done with it. And that's how justice is supposed to work, my friends. That's how these types of cases, that's what's supposed to happen. That's what's supposed to happen. Exactly, Carrie. Like or dislike Karen Reed, she deserves justice. That's right. And I don't know why people can't see past that. Those are true emotions. I was emotional for me or anyone, anybody who didn't get emotional watching that has no feelings, because Cami says, in my humble opinion, this case never should have been brought. This is justice, justice of procedure. And I tell you that every time we handle a case, we cover a case, I'm going to switch sides. I'm not a cupcake. It says that in my sign up there. I can't make everyone happy. I'm not a cupcake. Wherever it is, there's a pink sign. You can't read it. Sometimes I'm for the prosecution. Sometimes I'm for the defense. Sometimes I'm for the plaintiff. Sometimes I'm for the defendant. But what I am always for is the Constitution, rules of procedure, and the rule of law. And they have to be followed, or we don't have a system. And this was justice. And she did the right thing. And he's done. That case is over. It cannot be brought again. Somebody asked why it was dismissed with prejudice, and that is because jeopardy had attached. Once the jury is sworn in, jeopardy attaches. Under the U.S. Constitution, criminal defendant cannot be tried twice for the same crime. And that is the way it is in the United States of America. And that's the way it's supposed to be. Okay? So let's go to the Karen Reed case now. And I want to watch with you again the introduction of this Sally Port video, because the more I watched what went on with Alec Baldwin, the more I thought, this is really disturbing now, even more so in retrospect on a lot of levels. The breaking news that I will allow in the chat is if there's any more papers filed on Karen Reed today, like a defense response or another juror comes forward, anything like that. Mel Stiller says the U.S. Constitution is the most beautiful document I've ever read, and I'm Canadian. Thanks, Mel, for tuning in from Canada. Ruby says the harder they come, the harder they fall. One and all. Thanks, Ruby, for the 2. Shiraz says, thanks for the 5. Can you explain what jeopardy has already attached means? Yes, it means the jury has already been sworn in. What is the distinction when and how established? That's when the jury is sworn in. That's why how is double jeopardy without a verdict possible? Well, in this case, there was a dismissal instead of a verdict. So in this case, she dismissed the case without prejudice because she found, the judge in that case, Judge Summer, found that what the prosecution did by withholding that evidence under Brady was a Brady violation, and it was so egregious that it warranted dismissal of the charges because there was no way that the defense could have prepared properly because it was not discovered until day 3 of testimony. And that may be the difference between what happened in Karen Reed and what happened in Alec Baldwin. Nina, thank you for the 2 new case law for Karen's defense, State v. Baldwin. It's an oral decision. Thanks on top for the super sticker. You're on top of it. And Sherry, also thank you for the super sticker. Sherry Ebeling, thank you so much for the 10. Let's go back to day 20. This was day 20 of testimony in the Karen Reed case. Yuri was Commonwealth witness number 55. We were already 55 witnesses in when he came to testify. And let's watch a little bit of his direct testimony because it was Adam Lally who questioned him about the video initially. So you tell me what you think, whether they were trying to pull a fast one on the jury.
Some point subsequent to this, did you learn that there are exterior cameras of the Canton Police Department as well as cameras within the Sally Port garage area?
Yes, I did.
And have you reviewed each of those respective cameras prior to your testimony here today?
Yes, I have.
May I approach, Your Honor?
Yes.
Jason wants to know, what character can Alec
Which one you
Baldwin
would
play
just- just
in
have
Karen
to,
Reed film?
Look at that, look up when you finish.
Okay, so he's authenticating this
Do
CD
you recognize
ROM.
that, sir?
Yes, I do.
And what do you recognize that to be?
The Canton Police Department driveway with video.
And what's contained on that is that fair and accurate portrayal of yourself in the tow truck pulling into the Canton Police Department driveway on that afternoon or early evening of January 29th.
Yes, it is.
May I approach, Your Honor?
Yes.
Okay,
Almost seek to introduce the minutes of that.
so he's authenticating this as a fair and accurate representation of the outside camera of the Sally Port garage. Okay, remember, all these cameras are on the same system. We learned that because when I interviewed Craig of the tiny desk from the Karen Reed trial on Friday, that's what he said. Why would one of the cameras record in a mirror image when all of the other ones did not? So let's take a look. He authenticated this video as being a fair and accurate representation of the camera footage from outside the Sally Port watch. Okay, they're talking about it now. Watch Karen's face. Phoebe says they were trying to pull a fast one on everyone. And Bentley says 1,000% trying to pull a fast one. Yuri saying it's mirrored so fast on cross proves that, in my opinion. They're having a little powwow about this. There's Craig of the tiny desk right behind them. My cursor's not showing on my screen.
Thank you for that, Your Honor. No objection.
Okay.
So they're
Your
not
Honor, with the court's
objecting.
Permission, may publish that video to your agents.
Okay.
Okay, watch this video. It's got the blue timestamp on the bottom.
For reference points, in regard to this view of this camera, Sergeant, you're familiar with the Canton Police Station?
Yes, I am.
And so where is this camera view in relation to the Canton Police Department and the Sally Port garage where the vehicle eventually goes?
This camera is capturing the driveway entrance to the Canton Police Department. As viewed from Washington Street, that driveway there is on the left side of the structure. The camera itself is pointing towards the entrance of the driveway to the Canton Police Department. As you can see, the brake light illuminated in the shot. That is a Canton Police cruiser sitting at the edge of the driveway right by Washington Street.
So for orientation purposes, as far as the tow truck and your vehicle, is that coming from the top of the screen to the bottom or the bottom to the top?
It's coming from the
So again, Lally's asking him questions for orientation purposes, right? And he's saying, okay, it's going to come from the bottom to the top. I mean, from the top to the bottom. Wait,
top left to the bottom right of the screen towards the rear of the building where the Sally Port is located.
Thank you, Ms. Gilman, if you could.
okay. So is this video mirrored?
Now, as far as what's depicted in this still shot of this video, Sergeant, what if anything do you observe?
That is the tow truck transporting the defendant's vehicle, arriving at Canton PD. My vehicle with Trooper Proctor inside, me operating, are following closely behind, as we did the entire way from Dayton all the way to Canton.
Ms. Gilman, if you could play that to the end.
Okay, that doesn't look mirrored to me. Does it look mirrored to you? Lou Jones says, wouldn't it be a Hollywood fantasy to have Alex show up in Canton in a free Karen Reed t-shirt? When I was at Dave Matthews last week and I got within 5 feet of him for the entire night, I was wishing that I had like a free Karen Reed shirt sign that he could hold and I could take a picture of, but he did take a crowd selfie. If you don't follow me on Instagram, take a look at that. It's on Instagram. It was really cool. And I'm right there. and I have some really great video. However, did anybody go to the Mansfield show on Friday night? Did anybody have a sign that they got Dave to take a picture with? Because that would have been really cool. Okay, back to the subject at hand. This video did not look inverted to me. Did it look inverted to you?
Now, as far as the interior of the Sallyport garage,
Put the lights, thank you.
as far as the interior Sallyport of the garage, you mentioned that that is a heated area. Is that correct?
That's correct.
And as far as the heat within that, do you know how that is produced or how hot it gets in there as far as the time that you
Stupid
spent within
question.
there?
I do not know, but it was a standard garage heating system that blows hot air. As far as temperature, when the doors were open, that day it was freezing cold. It was, I believe, like 18 degrees with, winds blowing. So inside the garage inside the Sallyport with the doors open, it was quite cold. Once the doors shut, the temperature rose above freezing, and the snow began to melt off of the vehicle.
And from the arrival of that vehicle into the Sallyport garage area, are you aware or have you reviewed video in reference to that?
Yes, I did.
And Your Honor, may I approach?
Yes.
Okay, here's where he's going to authenticate this video. Somebody said, I'm surprised they have a CD burner still. That's a great comment.
Showing you another disc, sir. Just ask you to review that when you finish.
We are watching day 20 of the Karen retrial when the inverted
you recognize
Sallyport
that, sir?
video was
Yes, I do.
introduced
Does
into
that contain
evidence,
the video
which,
that you were
I don't know, may or may not be an intentional misrepresentation to the jury and the court. But, we're comparing this to the Alec Baldwin dismissal on Friday and how things are so different in Norfolk County, Massachusetts.
just testifying about as far as the arrival of the vehicle at the Canton Police Department Sallyport garage?
Yes, it is.
May I approach, Your Honor?
Yes.
How about proceed to introduce in the minutes of that exhibit? No objection, Your Honor.
Okay, he authenticated it. Fair and accurate representation.
Now, Sergeant, before we get to that video, if I could just ask, if you know, approximately what time was it that you left Dighton following that tow truck back to the Canton Police Department?
We left Dighton approximately 4:15, 4:20, and we followed the vehicle back to Canton, arriving probably around 5:30 or so.
Anybody remember what Proctor's original report said about what time they towed the vehicle? What time they got back? It's a lot different. Time was a lot different, but that report never made it into evidence because Proctor testified and Buchanan testified. Why would he lie about the time that they towed the car? Yep. Time was wrong, Danielle. Exactly.
PM.
Thank you, sir. And Your Honor, with the court's permission, if we could publish that video for the jury.
Okay.
Yep. He said 5:30. Kristen says. Okay, notice the blue timestamp on the bottom is not inverted, but notice the letters on this police vehicle are mirrored. Why is there snow inside that heated garage? Why is it in the perfect shape of a car? Did you notice the jump cut in that?
Ms. Gilman, if you could just pause there for a moment. Sergeant, direct your attention up to the video on the screen just for orientation purposes again. First of all, do you recognize what's depicted in this video?
Yes, I do.
What do you recognize it to be?
That is the Sallyport two-bay garage at Canton Police Department with the antique Canton Cruiser on the bottom of the screen and the open spot for a vehicle in the middle of the screen with the four-wheel drive all-terrain vehicle at the top.
Again, Lally asked him for orientation purposes. At any point, he could have said, but this is mirrored, so it's really backwards. But he did not say that.
Now, as far as, again, for orientation purposes, the driveway that the jury just witnessed in the prior exhibit, is that to the left of the screen, the right of the screen, or something else?
The driveway is to the right of the screen.
He knows that it's mirrored. He knows that it's inverted, and he has to think very carefully about how he answers that question. The driveway is to the right of the screen. When he said that, I'm assuming that there are garage doors on either side of that sally port, and I think there may be. But she's going to come in from the left side. Or, I mean, the car is going to be driven in from the left side.
And this vehicle, the defendant's vehicle is sort of taken into the garage from the opposite side or from the left of the screen, is that correct?
Correct.
Ms. Gilman, if you could,
Your Honor, may we approach briefly?
Okay. Then
Okay,
they
could you
approach
pause that, Ms. Gilman?
because now they're figuring it out. They're like, why is the lettering on that antique cruiser backwards? And Karen is like saying something to her parents like, it's backwards because they are purposely misleading the jury, says Maven 2017. Denise, how can Lally even ask these questions looking at an inverted video? Baffles me. Does he know? Is he an accomplice to this inverted video? Yuri's math teacher. Yuri's math teacher. That's great. Despicable shenanigans. Karen's shaking her head. She knows what's going on. She's more involved in her defense than any defendant I have ever seen be involved in their defense. You saw Alec Baldwin. He was shell-shocked the whole time. He wasn't writing notes. He wasn't participating. Scared to death. But now they're figuring it out. Now they're like, what is going on? Phoebe says, of course, Lally knew it was inverted. You'd have to be a moron to not know. Are you giving him too much credit, Phoebe? Yep. KPT, we're seeing her realize it right now. It becomes even more apparent when the car is pulled in and the number 4 is backwards. Brooklyn James says the original report said it was towed at 4:30. Yuri just told us it was, 5:30. Yuri just told us it was 4:15. So I'm going to imagine that what they're doing during sidebar is that Alan Jackson is arguing.
Take a short afternoon break on our long days at about a half an hour, but I think the better use of our time is to give you a 10-minute break now. And then we'll go straight through till 4 o'clock. And if anybody needs a break,
He's arguing that it should not be admitted, that it's not a fair and accurate representation. He's arguing that it should be thrown out. Who knows what he's arguing, because we don't know, because none of this is on the record ever. So let's see what she does next. Well hung jury says, I think this is one of the most misleading pieces of evidence in the trial. It's a disgrace. Lori Life 360 for the win. This seems like a Brady. That's what I'm saying. This is video from January 29th of 2022. They don't turn it over till April 24th, 2024, during jury selection. It's the wrong side, Karen just said to her family. It's on the left, not on the right. Then she realizes the camera might be on her. Toby Bird Dash says, oh, there's Craig. There's Craig again. Bias Bev is on the brink of serious issue. She chooses the wrong direction yet again. She's probably ready to retire anyway, so doesn't care. I don't know. I think she's in her 60s. I think she has her seat until she's 70. She was appointed. Little Cupcake says, that's how much they respect the jury. And stuff says,
May the witness leave the stand just for a moment.
Lally must have known. And now Lally
Yeah, we'll
asks
see you back
for
here in about 10 minutes, Sergeant.
Buchanan to leave the room. The judge must have said at sidebar, well, let me, oh, she said, Indie Girl said, she said it's the wrong way around.
You are unmuted.
Okay, so you want us to watch this now?
If you please the court, yes.
And Alan Jackson's like, yeah, Judge, we want you to see this because we want you to see how egregious this is. Some sigh emojis in the chat, members. Just heavy breathing in the mic. Okay, watch the jump cuts on this video too. Okay, so they're pulling in the car. When we were watching this in real time, I'm thinking to myself, as many of you were, okay, wow, that's weird. That rear tail light, the passenger side tail light, looks to be like it's white. Looks like it's maybe broken. Like there's a lot of white back there, right? A lot of white light. That's what we thought. And then I said, why is somebody getting out of the passenger side of that vehicle? Because if this was not shown intentionally to the jury to tell the jury or to confuse the jury or to make the jury think this is supposed to be the broken taillight, then I have no idea why they would have not pointed out that it was mirrored right away. So egregious. Watch. See how he just appeared right there? Just appeared. That guy just appeared like a ghost.
May I get just a little closer?
Sure.
And if you
Can we turn out the lights, please, Dave?
zoom
Thank
in,
you.
you can watch that timestamp on the bottom also jumping quite a bit. And now you see someone towards the back of the vehicle go over to what we now know is the passenger side tail light. This is the driver's side. It was hard for me to even wrap my brain around it when 20 people tried to explain it to me. In order to make that happen, in order to invert the video, you have to do that through a program. And then you'd have to repaste the timestamp on the bottom in its proper orientation. This is wild, I agree. Blessed Mom from Texas is right here. Should have been a mistrial or should have done something. This is wild. You can see now there are two people, no, three people back here by that passenger side tail light. GP Dog Drill says, anyone see Aussie Insider's video on the white light on the tail light? Microdots is a great one too. Yes, and we'll see if we can notice it in this video. But the videos that they have done show that white light move like to the back of a person's back when they go past it, as if it was added on after. It's really wild. So the judge is watching this now outside the presence of the jury. Again, it just jumped and some people appeared. There are more people now around the passenger area of the taillight. Is this potentially exculpatory? I think so. The defense has argued many motions where they argued that the taillight pieces were planted on the scene. At the scene, rather. They did object, Nina. It was all done at sidebar. We have no idea what was said. Now, as you watch this, thanks, Nina. As you watch this come down, see how the number 4 is backwards. It's inverted. All of a sudden, ghosts everywhere, says Anne. Yep. Oh, they're multiplying. And all of a sudden, they find the crime scene tape. They couldn't find the crime scene tape at the actual crime scene. They couldn't secure the crime scene from 8 a.m. when Canton PD cleared the scene until after 5:30 p.m. when the CERT team got there. Back and forth, using the crash dummy to secure the yellow crime scene tape. A lot of malingering around there, around the back. What we now know is the back passenger taillight. But we and the jury were led to believe that this was the driver's side. I mean, that this was the passenger side of the vehicle and that this is the passenger taillight that we see. But really, it's not. Caveman says, look at the top of the video. A woman walks in when they're pushing the snow. Yep, I noticed that too. Thanks for the 5.
Is that the end of it, Mr. Lally, or
I believe so, yes.
is that the end of it, Ms. Gilman? Okay. All right, lights on, please, Dave. Thank you. All right, so I have a copy of the printed docket on 4/24. Paper number 347 was the Commonwealth's Notice of Discovery XL. I just asked Mr. McDermott to print it for me. Our printer up here doesn't work.
That's when they turned it over to the defense on April 24th of 2024 during jury selection.
That was before we impaneled. That was the day, I believe, of the long motion in limine trial.
No, it was a motion to eliminate hearings. That was on a Friday. And that's when they turned it over. And therefore, you're going to allow it in. Okay.
All right, so we'll take a 5-minute break, okay?
Well, she took a 5-minute break, but then they come back from the break and then she's going to allow it in. So that's wild. They have had that video since January 29th of 2022. There is no good reason why it wasn't turned over until the eve of trial, literal eve of trial. And then here, let's watch this because he changes his mind later on when he points himself out in this video. All right, now the jury's back.
Thank you. Be seated. Close back.
All right, so we're ready to pick right up where we left off?
We're ready. Thank you, Your Honor.
So I'll just be clear, the objection's overruled, Mr. Jackson.
Here you go.
Thank you.
The objection is overruled, Mr. Jackson. We don't even know what the objection was. I'm going to assume it was late exchange, should be excluded. Clearly, it's not a fair and accurate representation. It's mirrored. It's jumpy. It's clearly been edited, doctored, proctored, intentionally, negligently. It's not a fair and accurate representation. He could have had many objections, but it was overruled. So we'll never know.
Sergeant, we're going to start up again with the video.
Yeah.
Nothing to see here, folks.
Your Honor,
All right,
for
Cynthia.
the record, I believe we're picking up where it was paused, which was 5:35:36.
Okay?
Look at somebody just appeared and then disappeared. Watch all the appearing and disappearing ghosts in this video. It's magical. The magical mystery Sally Port, I called it.
If you could pause right there. And Sergeant, as far as the condition of the vehicle as you observe it in this sort of pause still shot of the video, is that a fair and accurate portrayal of the condition as far as the snow or ice or anything you observed on that vehicle when it came into the Sally Port garage?
Yes, it is.
Just tell me if you could play from there.
Again, the jump. Jumps again, jumps again.
Tell me if you could just pause there for a moment.
Okay, now see he slipped at the top?
Sergeant's.
This is the guy that got out of what
All
we
right,
now
so
know is the
keep
driver's
your
side.
voice up.
Sergeant Mechanic, with reference to any individuals you see in this video, do you recognize any of those individuals?
I can recognize Trooper Proctor myself. Other than that, I don't remember exactly who else was present at this moment in time.
There's like 5 or 6 guys in
If
there.
you could start using the laser pointer before you just direct your attention to where you observe yourself and where you observe the problem.
That's Trooper Proctor and myself. Yeah.
Okay, he's pointing to himself as the guy who got out of what we now know is the driver's side of the vehicle. That's what he says. He says that that was him. He's wearing like a baseball style cap. He's the one who drove the car into the Sally Port. Picking up what I'm laying down here? On his cross-examination, he's going to deny that he said that. He's going to deny that that was him. He's going to say it was the tow truck driver. They wouldn't let it, the tow truck driver. That's evidence. Why would they let the tow truck driver drive that car in? Why is he going to now change his testimony and say that that's not him? I think he says it during direct, he never even said that. Let's let it play a few seconds.
You were present with this vehicle in the Sally Port garage this evening of January 29, 2022. Did either yourself or did you observe Proctor touch or manipulate in any way the right rear passenger side area of that vehicle?
No, we did not.
Ms. Gilman, if you could play from here.
The right rear passenger side of that vehicle, which we assume is this part here with the white light, but it's not. Look the other way. It says Mom for Life. That was the theme of the closing of Alan Jackson in this case. Thanks for the 2. That's still Yuri going in the driver's side again. It's crazy. Lorena Jenkinson, you were in court that day? Says it was epic. Amanda says, I honestly assumed Karen Reed was guilty because of the media reports. So when everyone was covering the trial, they thought, what the hell? It's a slam dunk. There's video proof she hit Officer Don O'Keefe. Man, I was wrong. Yep. They told the media they had Ring doorbell footage of her hitting him with her car, but that never surfaced. That was a lie. Monique, Coach Mo, thanks for the 10. I've been so confused about this video. What or why was having a mirrored video relevant for the Commonwealth? Can you please explain? Thank you. Yes, because they wanted the jury to think this is the passenger side of the car. Look, nobody ever went around that taillight. Look, there were some white pieces, so it must have been busted up, must have been shattered. See how they're all malingering around what we now know is really the busted taillight, the shattered taillight? Smoke and mirrors. Land of confusion. Elf for gifting a membership, and thanks Toots for becoming a new member. Little woman 411 Lally knew because Bukaki's Buchanan said the driveway was on the right, which it would be if not inverted. Yet Lally says it will come in on the left. I was confused by that too, because I thought it just meant there was a door on the other side of this garage. I mean, it was more confusing if anything else. I thought it meant that the driveway was on the right, but they drove it around somehow and got it into the other door. I don't think it was clear. You know what I mean?
I want to take a pause there just for a moment. Dr. Buchanan, from what you're observing in this video, what you've seen or what you recall from this, what is it that you and Proctor and some of the other officers are doing now?
We're establishing a perimeter around the vehicle with yellow tape in order to prevent or alert and advise anyone in the area to stay away from the vehicle.
Yep. Next day he acted as if he didn't know his Proctor. Yeah. Crazy how that happened, right? Yeah, so this goes on and on and on. And as you can see, I'm annoyed by it. Was it intentional? Was it not? Why did the judge allow that in when it was clearly turned over on the eve of trial and there's no good reason for it? I'm gonna pull up the cross about this part where it's pointed out. Just gotta rewind it a touch. Okay. This is the cross-examination with surgical precision, courtesy of Alan Jackson, Esquire. And this was day 21 of the trial.
May I inquire?
Yes.
Thank you. I'm trying to use my time wisely, Your Honor. Yesterday, Sergeant, you were asked about a couple of videos related to the Sallyport garage. Do you have that in mind?
Yes.
As a matter of fact, we watched one of them pretty specifically toward the end of the day yesterday. Did you actually, I want to talk about the one that is the clearer of the two, where you slip. You remember that one?
If you pull it up, I can.
I will in just a second.
Okay.
There was one where Mr. Lally paused it and you were slipping in front of the vehicle.
I don't recall myself slipping, no, but it was
We
icy
just
that
saw-
day. So
we
if
just
there's
watched it.
documentation of me slipping, I might have happened.
Fair enough. I didn't mean anything by that other than that was a moment that I thought you might recall to differentiate the videos.
And remember, they had an entire night, or was this over a weekend? Now I can't recall what day this was. Hold on. Why doesn't it say the exact date here? In any event, they might have had the whole weekend to prep for this. I can't recall if it was a Friday.
It's exhibit
was overnight.
446, but I don't think that's going to help you. All right, let's see if I can do this another way. Did you actually personally go to Canton Canton PD to retrieve any or all of the videos of the Sally Port? You yourself?
I did go to Canton and collect already extracted video,
Okay.
but it was a portion of video surveillance. I didn't collect all of the video, so
When was the most recent time that you went to Canton to collect a portion of the video?
I don't remember. I
Mm.
don't remember. I'm sorry.
Did you review well, let me ask it this way. Did you collect the video that was sought on or about April 23rd, April 24th this year?
Of this year,
A few weeks ago.
April 23rd or 24th of 2024.
Did I collect it?
Correct.
I did not collect that video of April this year. No.
You're aware that the video that you saw yesterday was in fact collected after the trial started in April of 2024.
Mhm.
Yes.
Sustained.
Are you aware of when that video that we saw yesterday was collected?
Objection.
I am not aware.
Okay. Was yesterday the first time you'd seen that video?
No.
When had you seen that video previously?
A couple of weeks ago.
Okay. What were the circumstances in which you saw that video?
Objection.
Sustained.
Did you have a meeting with the DA?
Objection.
Sustained.
Well, that's interesting. He's been prepped on the video, but they never turned it over to the defense. See what's going on here?
Did you ever have any kind of communication with Mr. Lally about your testimony?
Objection.
Sustained.
May we approach?
Yeah, please approach. Then they approach, and he's like, Judge, this is so egregious. They just turned this over on the 24th of April, and now we're just going to act like that didn't happen. And I'm not even going to be allowed to inquire about that, about the late exchange, and about the fact that this wasn't even turned over until trial. It's insane. This is very, very similar to what we just watched in the Alec Baldwin case. This is potentially exculpatory when there's a Bowden defense, when there's a third-party culprit defense.
You are unmuted.
May I?
Yes.
Thank you. Sergeant, did you have any meetings or communications with Mr. Lally in anticipation of your testimony?
Yes.
When was that?
It was about 2 weeks ago. And then last week, I believe.
And what was discussed? Generally.
Generally, we discussed the portions of the case that I would be presenting.
Did you write a
Presenting.
report about your communications with Mr. Lally?
No, I did not.
Were you shown any of the videos that you've seen here in anticipation of your testimony?
Not during the first meeting. I did review a video during the second time.
Okay, and that video was that you did see the second time was the interior video of the Sally Port that we saw yesterday, correct?
I'm just trying to remember exactly what video I saw. I had reviewed videos outside of our meeting, so
Somebody else
I
showed you
don't
videos
remember
too?
exactly what video Mr. Lally showed me.
But you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene taping put up and all that. You have seen that one before,
Yes,
and that was with Mr. Lally, correct?
that is not correct because I do not recall when I saw that video or what video I saw with Mr. Lally.
I see. All right. I'd like to talk about that exhibit 446 for a second, and then I'll show it to you. You indicated that the video that all the videos, everything that you saw yesterday was true and accurate, correct? Based on your memory of the events that were memorialized in the video?
The video captures events taking place in an accurate fashion, yes.
In an accurate fashion. All right, that's what I wanted to find out.
In an accurate fashion. Okay, let's see how he tries to rehabilitate himself on this. Like, this is egregious, you guys.
And after you watched the video, I think you were asked by Mr. Lally, does the video show you or Trooper Proctor having access to or messing with in any way that right rear tail light in any fashion? And you said, never.
I was asked if at any point Trooper Proctor and I had came into contact, I believe, or touched the vehicle and that portion of the vehicle, and I said never. We never touched the vehicle prior to it being properly processed with a search warrant.
And that was specifically his question was to, and your answer was to the right rear portion of the vehicle, right? That right rear tail light.
The right rear damaged taillight, correct.
With the court's permission, I'd like to play a portion of Exhibit 446.
Okay.
Arrogance.
Before we begin playing it, Mr. Bates, if you wouldn't mind, may I inquire, Your Honor, of the witness, just to lay a foundation? Sergeant, do you recognize this as being the video that we saw yesterday?
It does look accurate.
Okay.
Yes.
I just wanted to make sure we're on the same page. This is 446, just so you have it in mind if I reference that. Bates, if you could play that. And I think it's runtime 120. Pause it. Do you recognize that as the video we saw yesterday?
Yes, I do.
That's him holding the crime scene tape because he's got the baseball cap on.
Very briefly, if you could move to time of day, 5:37:05.
Yep, that's the driver's side, Phoebe. I know it's hard to wrap your head around it, but it is.
Yes. With court's permission, can we play at this point?
Yes.
All right, that shows the vehicle coming into the Sally Port, and we're looking at which side of the vehicle?
So that is the driver's side of the vehicle. What that video depicts is a mirror collection. Although mirrors are accurate representation of what you're seeing, it's just inverted. So that is the driver's side.
It's just inverted. Although a mirror is an accurate representation of what you're seeing, it's just inverted. He had all night to prepare for this. I think you're right. I think this was like a Thursday into Friday, and then he came back on a Monday to be cross-examined again because I think he was on that stand for 3 days. Can you imagine? This is how it comes out. I almost wish it happened the same day that he was on the stand to begin with, so they didn't have time to prep him on this, but listen to this answer again. We're looking at which side of the vehicle?
Side of the vehicle.
So that is the driver's side of the vehicle. What that video depicts is a mirror collection. Although mirrors are accurate representation of what you're seeing, it's just inverted. So that is the driver's side of the vehicle. I do not know why it is inverted, but that's the way it was presented, collected and presented from Canton Police.
Can
Oh.
you see a timestamp or a time and date stamp on the bottom of that? It's in blue.
I cannot know.
Okay. Does it appear that time and date stamp, if you can't read every letter on it, that is in correct order? In other words, that's not inverted.
I cannot read it, no.
Get up
Let's
and
go
look.
play this for a second.
I don't know why it was inverted. Just appearing out of
Who's that
nowhere.
that just got out of the car?
I do not know. I think that's the tow truck driver. He would have the only access to the vehicle.
Liar. Liar. You said that it was you in the last video. You said that it was you. We watched it twice. Now it's the tow truck driver. Apparently somebody got in touch with the tow truck driver. I can't remember who, if it was Sean McDonough or somebody, Aiden Carney. And the tow truck driver says he never went inside that car. He never drove that car. So why is he now lying and saying that's the tow truck driver? Strains credulity.
We did not touch the vehicle.
Uh-huh. You
Who's
drove
that
it
on
in
the
there.
left?
I missed that. I was looking down at the laser pointer. I do not know. I know for a fact I'm the gentleman that's wearing a dark olive drab state police baseball style hat, and Trooper Mike Proctor is wearing a winter hat.
Trooper Proctor's wearing what?
A winter hat.
This was shown to deceive the jury, and he just threw Canton PD under the bus when he said, I don't know why it was inverted, but that's the way we got it from Canton PD. Right, Lucy. He says, we didn't touch that vehicle. As he opens the door, he's opening the door again. He's going over there with a little hand truck. He drove it into the Sally Port. We watched him get out of the car. That guy has a baseball cap on, and that guy is him. And there's-
Yesterday, when you testified, you indicated that the two individuals in this scene were you and Trooper Proctor, correct?
Not correct. There was two individuals in the rear of the vehicle. I shined my light to. That was me and Trooper Proctor.
Do you see Trooper Proctor toward the back of the rear of the vehicle there?
I can't tell because of what the head is. I just know that Trooper Proctor was wearing a black hat.
Which the person in that, in the video to the left, to the rear of the car is wearing a black hat, correct?
I can't tell. I don't want to be locked into a statement where later on you show me that it's somebody else magically. I can't testify to that.
Magically, well, sir, there's a lot of things that magically happened in this video, like people appearing and disappearing, you magically turning into somebody else from yesterday's testimony where you pointed to that as being yourself. Lisa says Yuri should lose his job for lying under oath. Oh, your time is gonna come. That's in the playlist, my friends. We have a Spotify playlist for this trial because I think in song lyrics, and that's in there. The Magical Mystery Tour is also in there because this is just the Magical Mystery Sally Port.
No magic about this. It's your testimony. I'm just asking you what you see.
I don't see that. No.
Let's go ahead and play it this way.
What is he doing? Is he taking a picture of? Oh, he's actually taking a
See the
picture.
person toward the back of the vehicle, walking toward the opposite side of the SUV.
I do.
What area does he appear to be going to?
He appears to be going towards the rear passenger side of the vehicle, although it does not appear so because the video is inverted, a mirror image. That's where he's going.
And
Mhm.
Sergeant Buchnick, you testified for at least a half an hour about this video yesterday, correct?
I'm sorry, it was a long day. I don't know the timing of how long I testified.
You significantly testified about this video yesterday, did you not?
I testified about this video.
And you testified that it was true and accurate, correct?
Mm-hmm.
Correct.
You testified that it was reflective of your observations of what was happening in that Sally Port that evening, correct?
I testified that this is a accurate scene and collection of video evidence from the Sally Port.
And as that truck sits in that Sally Port, just like this, it appears from all perspectives that what we're looking at is the passenger side of the car, and that right rear taillight is right there shining in our face, correct? From this perspective.
Mm-hmm. That's right.
I'm sorry, can you repeat the question?
From this perspective, from the perspective that the jurors are looking at,
Okay.
from all indications, that would appear to be the right side of the truck, the passenger side of the truck, and that taillight that you can see is the right rear taillight from this perspective, correct?
The way it presents itself, yes.
And yesterday, during the entirety of your questioning by Mr. Lally, not once did you mention that this video is actually completely inverted.
I did not know.
Mr. Lally didn't ask you if it was inverted, correct?
That's correct.
And if I hadn't gotten up here and begun questioning you, that would be left uncorrected, correct?
Objection.
Sustained.
But
The
he's
person
right.
with
But he is right. Did the Commonwealth think that they were just going to pull the wool over everyone's eyes and the defense wasn't going to notice? And the defense wasn't going to point it out? Because for what other reason would that video be shown to the jury if not to mislead them and us? We watched it together live.
winter cap appears to walk directly to the what ultimately should be the right rear tail light of this car, correct?
That's the vicinity, yes. That's where he is, yeah.
That's on the playlist, Scott. Whoa, ho, ho, it's magic. You know, never believe it's not so. Yeah, this is so egregious.
I'd like you to pay attention to the right rear of this car. And I know we're completely backward, but it's the far corner.
Okay,
of
and
the
then
car.
he's going to point out,
Do you
like we
see
watched
versus
before,
that?
like I pointed out the first time, that how many people were lingering around that taillight, and he doesn't even know who most of them are. But then, of course, there's another video that turns up from the Commonwealth that is very grainy, and I don't know if it's in this day's testimony, but you may recall because they showed it during his testimony, and it may be on his next day of testimony, but that video is not mirrored, and that's from another camera inside the interior of the Sally Port. So who did this? Was it intentional? It had to be done there had to be some thought put into it. Oblivious Benson, what say you? If the other cameras on the system inside the Canton PD Sally Port and exterior cameras don't record in a mirrored image, why would that one? A lot of people think it's intentional. They had to pivot during trial to figure out how to address this. They made motions that we didn't hear about. Oblivious Benson says, I agree. The colors on the other were yellow. No, some of them were, they were blue as well. But it not only would you have to first mirror the video or invert it, you would then have to put the timestamp back on correctly. And he says that he did it. He didn't do it. It wasn't me. It wasn't me. He says that he got it from the Canton PD, and he doesn't know why it was like that. And let's remember, shall we? I put the link to the show that we did together on the motion to recuse in the video description here, because if you have not seen that, you should go watch it. That was fire. That whole hearing was fire. This judge had every opportunity to dismiss the Karen Reed case, and she wouldn't. She would not do it. She would not recuse herself. She would not take DA Morrissey off the case. She would not dismiss the indictment because of the lies that were told to the grand jury by people like Proctor. She had every opportunity to do the right thing, and she didn't do it. You know who we saw do it? Judge Summer did it for Alec Baldwin. And we don't even know if that information, if that evidence that was withheld from the defense would have been exculpatory. It doesn't matter. And here's how we know that Michael Morrissey is very, very, very aware of Brady and its implications. Because these letters were released during the pendency of this litigation. We did a whole show on this too. But here's a letter dated May 9th, 2023. Okay. Remember that Sallyport video is not turned over until April 24th, 2024. This is a letter to Joshua Levy, who was the acting U.S. attorney for the state of Massachusetts, which was investigating the investigation. And Michael Morrissey found out about it because people like Jen McCabe, Brian Albert, Brian Higgins, Matt McCabe started getting subpoenas to come testify in front of a federal grand jury. And Michael Morrissey started freaking out, maybe. So he started writing these letters, and we did a whole show on that. But here's the first one, May 9th of 2023, to Josh Levy, after they apparently had a phone conversation in which he says, I write to follow up on our conversations regarding the issuance of federal grand jury subpoenas to at least 2 witnesses to the Commonwealth's investigation into the death of John O'Keefe. As you know, indictments have issued in Norfolk Superior Court and the prosecution is ongoing. See the Commonwealth versus Karen Reed. As a prosecuting agency, the Norfolk District County Attorney's Office has the constitutional duty to provide the defendant with exculpatory evidence. The obligation in Massachusetts to provide exculpatory information pursuant to Brady v. Maryland and its progeny means not only the constitutional obligation to disclose exculpatory information, but also the broad obligation under our rules to disclose any facts that would tend to exculpate the defendant or tend to diminish his or her culpability. Under Massachusetts rules of criminal procedure, mandatory discovery includes all facts of an exculpatory nature and all statements of witnesses. And he goes on and on and on, requesting for the feds to give them whatever statements of witnesses they took that are relevant to the investigation of the death of John O'Keefe so that they can turn them over to the defense. And then they even, let's change it to the next page. Page 2 of their letter points out more. While we are unaware of the parameters of the federal activity, we cannot forego our constitutional or state duties. We are willing to file a motion for a protective order under Massachusetts Rule of Criminal Procedure 14A6 to request limitation of the disclosure of the information to defense counsel only. Any decision of such request, of course, is solely within the authority of the Norfolk Superior Court judge. Next paragraph says, additionally, this office has constitutional and state obligations to provide exculpatory information of which we are aware in all cases, including exculpatory information relating to all witnesses and or members of the prosecution. This would include any investigations into misconduct related to professional duties. If any such information exists, it's imperative that we learn of it in a timely manner. In sum, while we appreciate the notification that subpoena is issued, it's imperative that at the earliest opportunity, we are able to provide discovery to the defendant. Really? XOXO. Oh, Marcy didn't even sign this one himself. He had the first assistant AD sign it, Lynn Beland. But he signed some other ones, and you know because we went over them. And then what wound up happening was that Joshua Levy turned over 3,074 pages of material to both the defense and the prosecution because Josh Levy said during a conference call to both of them, in good conscience, we cannot allow the Karen Reed case to go to trial. And yet here we sit after a hung jury, after at least 2 jurors and 2 jurors through intermediaries who have come forward and said, we acquitted Karen Reed on murder and count 3. We were only hung on count 2. And we are waiting to hear what the court does with that. Next. David, thanks for the 10. Do you think the defense should have filed a motion to dismiss after Nicole testified that she told the DA where Chloe was? To me, that seemed like a Brady violation. I was going to bring that up. It's just one more thing that they hid from the defense, right? We don't know what motions or objections were made outside our presence because we didn't get to hear any of that stuff. But all of a sudden, Nicole Albert testified on the stand after the defense has been told for years they don't know where Chloe is. Nicole testified that she knew where Chloe was, and she told the prosecution where Chloe was. In fact, she said, I drove halfway to meet the woman from Vermont that we rehomed her to. And I know where she is just in case, or she called Chloe it, just in case they would ever be needed for anything else. It. Diana Miller, thanks for the 5. I dislike Seth Kenney so much, and he and Dave Hall, not plea deal, should have been charged. Judge Summer was excellent. Bev needs to take note, but won't. It's just amazing how on one side of the country, the interpretation of the Constitution can be so different. Caveman, sneaky, they all lie. Thanks for the 2. Nina, thanks Nina for the 5. Why didn't AJ file a motion to dismiss after the Sallyport video is clearly exculpatory? I'm sure he moved to exclude it or asked for an adverse instruction. We didn't see any of that. There was nothing on paper that we know of. Could be an appellate issue. At this point, we have to see how this goes. What happens next? Daria, thanks for the for gifting a membership. That's so generous of you. Michelle, thanks for the 5. If it was really broken when they picked it up before driving away with it, they would have taken hundreds of pictures and videos immediately with timestamps. Yep. Don't you think? AAA takes a picture of your car every single time they tow it, or every single time they tow anybody's car because they don't want to be liable for any damage that was already existing to your car. So, really? Elf, why didn't the tow truck driver testify? I do not know. I don't know. Blessed Mom from Texas, thank you for the 20. In the Alec case, it blew my mind how many people called it unfair. No, it's not. It's our constitutional right. Prosecutors and law enforcement are getting brazen. Karen Reed case right here should be a Brady violation as well. Thank you, Blessed Mom from Texas. I agree. Like, we have to follow the Constitution. Defendants are entitled to a fair trial. This is insane that this is still continuing, that it was even prosecuted to begin with. Caveman, they're roping of the car. Nothing at the Alberts. Nope. Thanks, Caveman, for the 5. But no, there was no crime scene tape of the Alberts because it was so windy. It wouldn't have worked. Wouldn't have worked, they said. Andre, thanks for the 5. Check your Instagram messages. That's my real face and name. I sent you a weird taillight video. Also, I literally love you. You called me Mimi. It's Melanie. Thanks for everything you do. I know that was just a typo. I don't know if I can pull that up right now. But Microdots has it, and I believe Aussie Insider has it as well. And if you send me Instagram messages, just so that all of you guys know, it is, they get lost in like some black hole. So I don't really know where this is because I can't find it. They go into like 3 different columns and I don't get notifications, but Aussie Insider has it. Check out Aussie and subscribe to her, and as Microdots as well. Thank you so much. Hey, it's Chaos Coordinator. Thanks for the 5. How did he have the conscience to sit on the stand and testify, looking at the video and knowing it was rigged? Shaking my head. Shake it. Shake it. Sugary. Magnus, thanks for the 50 coming in from, I think, Denmark. I'm confused if it was turned over before or after Higgins' testimony, and love your coverage. Thank you, Magnus. This was turned over April 24th. That was a Wednesday. Openings started Monday, the 29th. So it was during active jury selection. The jury had not yet been sworn. Maybe they were not even impaneled. I mean, they may not have not finished jury selection. Those are the only notes that I have here. So it was definitely before openings even started. Maybe that's why it's not considered a Brady violation, because the trial hadn't actually started yet. I don't know, because they actually did turn it over. It was just way late. Gift in the car, thanks for the 5. I'm dyslexic and had a stroke and a TBI and could tell it was wrong way around. It was so bad. I'm so sorry that that happened to you. That you had a stroke and a TBI. I'm so sorry. The whole Commonwealth from Bev on down needs to end up in jail. We'll see. So far, we only know about Kevin Albert being on leave with pay, I think, paid summer vacation, and some sort of investigation into him. And Trooper Proctor has now been suspended without pay, I believe. And there's some sort of petition to get him his health insurance for his family. Poppy, thanks for the super sticker. Appreciate you. Mars Bars, thank you so much for becoming a member. C. Taylor says, why does perjury rarely have consequences? Well, we did see someone go to jail for perjury, and that was in the Adam Montgomery trial out of New Hampshire. Those of you who know. Adam Montgomery was convicted of taking the life of his beautiful 5-year-old daughter, Harmony Montgomery, and that I think was out of Nashua, New Hampshire, maybe. And Kayla Montgomery, Adam's wife, lied to the grand jury and said that she was working at Dunkin' Donuts when Adam took the life of Harmony. And it turned out that she committed perjury and she went to jail for something like 2 years. So sometimes it does have consequences, and it's no joke. Charlotte says, I think they could have spelled out exculpatory implications of the corrected video more clearly. Yes, and I am very annoyed that they only had an hour for closings, because I just don't think that was enough time. There were so many things to cover in this case, and it just was not enough time. Scott McGinnis, hello. Thanks for coming in. If not for Turtle Boy, the feds, Karen's stellar defense team, the upswell of the Free Karen Reed movement, Karen Reed would have been steamrolled by this massive corruption machine. Still going on, though, isn't it, Scott? What's the judge going to do? Is she going to have a hearing? Is she going to call the jurors in? She better. Because if she doesn't, then nobody wants to know the truth. Nobody wants to know the truth. Except us. The Commonwealth doesn't want to know the truth. Isn't this about finding out the truth about what happened to John O'Keefe? Not about just getting a conviction. Green Beagle, Bev dismissed the court for the day before AJ could cross-examine about the inverted video. When he went home and knew what they knew, he testified different the next day. Yep. The Maven. He says the taillight is white as if it is the broken taillight. Yep. He also identifies himself in Proctor, then changes on cross to the tow truck driver. You saw it here. We played it back. Danson Bear says, in my opinion, Spyro knew about the hidden evidence, and that was the mode of his questioning, to set the prosecutor up for suppressed evidence. Yeah. I haven't watched all the testimony, truth be told, so I would need to go back and watch all of that, but that's what I heard as well. Susie Blue Sky, how come Jackson and Yannetti didn't do anything about these things, though? I'm worried it's too late. There's always appellate issues. But we don't know. Again, everything was done sidebar. There was hardly anything done in open court, which is unlike many of the other cases and other trials that you've seen and we've watched and that I've seen. Daria says, imagine thinking up inverting the video. I mean, that takes a lot of deliberate malicious planning, doesn't it, though? Doesn't it? Caroline, this is unbelievable. Imagine being on trial for murder and the police hand over a video like this and never disclose it's a mirrored image. I'm so disgusted to even live in this state and scared. I think you're not alone, Caroline. You are not alone. Out of scope. Doesn't remember the slipping. There was no reason for him to have denied something embarrassing that he definitely would have remembered, other than to dispute everything the defense suggests. Yep. Miss Adventures Book Mouse, thank you for the 5. This definitely is probably withholding some witness / evidence, because technically they didn't have to prove anything, but that there were holes in the prosecution's case. Yep. They didn't have to prove anything. Melinda, when is it double jeopardy? When it's a bench trial? I would say when openings start. Double jeopardy would attach as soon as the trial starts. Thank you, Melinda, for that. What say you, my friends? What say you? Can we get Judge Summer to come to Norfolk? Wouldn't that be fantastic? Thank you, Justin, so much for the Cash App today. And Maureen Francis, as always, for getting in there early with the Cash App. You are so very kind and generous. As always, my friends. Anyone know where, hi, Aunt BB. Anybody know when Proctor gets his walking papers? I thought there was a trial date set for Proctor. You mean a hearing date? I don't know. I don't know. If anybody gets it, send it to me. My email is fanbase@mlittlelaw.com. That is fanbase@mlittlelaw.com. I appreciate you sending documents, thoughts, concerns. I don't always respond to your emails, but I always read them. Thank you to my moderators for keeping the chat classy today. Something to think about, Baldwin versus Reed, and how we can have two completely different outcomes on two completely opposite sides of the country. It's crazy, right? It's crazy, but I think that the Constitution should always win. Just like that quote that we heard from John Adams at the beginning. If I could find it again, did I close that tab? Where did it go? John Adams has been quoted throughout this trial. So I pulled up a quote from John Adams earlier today that I thought was very fitting for the stream. John Adams said, "It is more important that innocence be protected than it is that guilt be punished, for guilt and crimes are so frequent in this world that they cannot all be punished. But if innocence itself is brought to the bar and condemned, perhaps to die, then the citizen will say, whether I do good or whether I do evil is immaterial, for innocence itself is no protection. And if such an idea as that were to take hold in the mind of the citizen, that would be the end of security whatsoever," said John Adams. Thank you, moderators, for keeping the chat classy today. And thank you all for coming over and hanging out with me for a little while. And to my members, thank you for being members. Everyone, please hit the like button on your way. It helps the algorithm, all those YouTube-ish things that YouTube likes you to do for the algorithm. Hit the, subscribe button. It's free. Hit the bell so you know when I go live. And, that would be really awesome. It would really help the channel. That would be greatly appreciated. We're almost at 65,000 subs. I'd love to get to 70 before the end of the month, or 75 even. That would be totally awesome. It's free to subscribe. And just hit the bell so you know when I go live. Thank you for everything today. And remember, as I always say, to end every stream, be cool, be kind, be classy. It's not hard, really. Really, it is so not hard. Peace out, my friends. I'll see you soon. But if you don't hit the bell, you're not going to know when. Have a great rest of your day.